I told you that the last section in the Indian Penal Code, 1860, is 511. 511 deals with attempt to commit an offense. He attempts to commit an offense, but it is foiled by somebody. Attempt to commit an offense itself is an offense. Even if a person commits attempt to commit an offense, itself is an offense. For example, I have locked the door of my house and I have gone out. By the time I come, I find somebody trying to manipulate with the lock of my house and open it. His intention is to commit theft. I catch hold of him, subject him to the process of law. It is an attempt to commit theft. So when an attempt is made, he is punishable with an imprisonment which may extend to one half of the maximum punishment provided for that particular offense. What do you mean by that? If a theft is committed, under section 379 of the code, similar section is there in Sanhita also, the maximum punishment is it may extend up to 3 years or fine. So here it may extend up to 1.5 years or fine. That section 511 in IPC has been brought in the Nyaya Sanhita at numerical 62. So section 62 is 511. Why I am telling this is, when we are reading the provision, so attempt to commit an offense is not an offense. You should not come to that conclusion. 511 has been brought under a separate category, that is abetment, criminal conspiracy or attempt. So it has been brought under the separate chapter, and 511 has been brought here as section 62. Then, chapter 5. Chapter 5 deals with offences against women and child. This chapter has got 5 parts. The first part is sexual offences. Section 63 to section 73. Code, section 375 and 376. Of criminal force and assault against a woman. Section 74 to 77 of Sanhita is equal to section 354, 354A to D of Code. Of causing miscarriage, section 80, offences relating to marriage, section 80 to 87. Offences relating to causing miscarriage, 88 to 92. Offences against child, section 93 to 99. All those offences which are in the Indian Penal Code have been brought here and categorized and grouped under one separate chapter of that particular category in 4 parts. Now, there is one beautiful change in this particular chapter dealing with of sexual offences. What is that? Section 63 defines rape. That is equal to section 375 of the Indian Penal Code. It defines what do we mean by rape, under what circumstances it could be considered as rape. 2 parts are there. In that context, 2 subsections are important. Number 1, a person committing a sexual act on a woman who is under the age of 18 years, age is very important, who is under the age of 18 years is rape whether she has consented or not consented. That is, consent is not material. If the woman is under the age of 18 years and if a man has committed such an act and he cannot plead, she has consented, therefore I did it, that consent is immaterial because it is a child. You can't take the consent of a child. A child's consent is no consent at all. Even Contract Act doesn't recognize any contract entered into a child. So what is the significance of this? Then you come. There is one exception, exception 2, under the code. What is this exception? If a sexual act is committed by a husband on his own wife who is not under the age of 15 years, is not a rape. ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದು ಕಷ್ಟ ಇದು. Is not a rape. That means they say if the wife is 15 years and above, and if an act is committed by the husband, it is not a rape. What is the anomaly here? Anomaly here is Human Rights Act of 1983 defines a child as a person who has not completed 18 years. A female. ಅದು ಜನರಲ್ child. If you come to Prohibition of Child Marriage Act, a child is a person who has not completed 18 years in case of a female, and a male is 21 years in case of a male. If you come to Juvenile Justice Act, as I have already told you, any person who has not completed the age of 18 years is a juvenile. If you come to Domestic Violence Act, any child is a person who has not attained the age of 18 years. But here, if such an offence is committed by a husband on his own wife, don't mistake me for using the word own wife. ಅಲ್ಲಿರೋದು own wife ಅಂತಲೇ ನಾನು ಅದಕ್ಕೆ own wife ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ. So, if such an act is committed on his own wife, and if that wife is 15 years more, 15 years and above, less than 18 years, it is not a rape. POCSO Act says that a child is a person who has not completed 18 years of age. Any person. It don't say, it does not include married woman. No, it don't say. So even if she is a married woman, for all purposes, if she is under the age of 18 years, she is a minor. She is a child. So POCSO Act says any such child is punishable for an aggravated sexual intercourse. Am I right, madam? All these are used. I mean, aggravated sexual intercourse, sexual harassment, for all that even a child is punishable if it is under the age of 18 years. But why this concession? Why this concession? If the wife is above the age of 15, above 15 years and under 18 years, it is not a rape. This is what, in one of the judgments of the Honorable Supreme Court, reported in 2017, Volume 10, Supreme Court Cases, page 800, in Independent Thought versus Union of India and another, the Supreme Court has pointed out this anomaly and directed they examined each and every option, whether this could be done, that could be done. They have examined each and every option. 4 options were there before the Supreme Court. All the 3 options will say, no, it is not permissible. And last option 4, the Supreme Court said, therefore, there is absolutely no other option but to harmonize the system of law relating to children and require exception 2 to section 375 now to make it meaningful to read as sexual intercourse or sexual act by a man with his own wife, the wife not being under the age of 18 years. So now 15 has gone, 18 has come. When 15 has gone and 18 has come, it is harmonious construction with other sections, relevant similar sections found in other enactments which I have said. That is Human Rights Act, Domestic Violence Act, Prohibition of Domestic Violence Act, Prohibition of Child Marriage Act, and POCSO Act. In all these, Juvenile Justice Act, in all these acts, a child is defined as a person who is under the age of 18 years. So this is another important amendment that has been brought in the form of law, in exception 2 to subsection 2 of section 375 of the Code and section 63 of the Sanhita. And all other sections are, of course, remains the same. There is absolutely no change in that particular section 63 dealing with the rape vis-a-vis section 375. It remains, but one section has been added. What is that section? It is section 69.
18 ವೈಟ್ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಯಾವ ಲಾ ಪರ್ಮಿಟ್ ಇದೆ?
It's a good question. It's a good question. ಯಾವ ಲಾ ಪರ್ಮಿಟ್ ಮಾಡುತ್ತೆ ಅಲ್ಲ, ಯಾವ ಲಾನು ಪರ್ಮಿಟ್ ಮಾಡೋಲ್ಲ. ದಟ್ ಈಸ್ ವೈ ಚೈಲ್ಡ್ ಪ್ರಾಹಿಬಿಷನ್ ಆ್ಯಕ್ಟ್ ಇಸ್ ದೇರ್. ನೀವು ಕೇಳಿದ್ದಕ್ಕೆ ಹೇಳಬೇಕು. ನಾನು ಯಾಕೆಂದರೆ ಟೈಮ್ ಕನ್ಸ್ಟೆಂಟ್ ಇದೆ ಅಂತ ಜಾಸ್ತಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡೋಕ್ಕೆ ಹೋಗಿಲ್ಲ. ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ಅರ್ಧ ಗಂಟೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೋದು. ಚೈಲ್ಡ್ ಪ್ರಾಹಿಬಿಷನ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಪ್ರಾಹಿಬಿಷನ್ ಆ್ಯಕ್ಟಲ್ಲಿ ಎ ಚೈಲ್ಡ್ ಇಸ್ ಅ ಪರ್ಸನ್ ಹೂ ಈಸ್ ಅಂಡರ್ ದಿ ಏಜ್ ಆಫ್ 18 years in case of a female and under the age of 21 years in case of a male. ಇದು ಬಹಳ ಮುಖ್ಯ. ಯಾಕೆಂದರೆ ಎಲಿಜಿಬಿಲಿಟಿ ಫಾರ್ ಗೆಟಿಂಗ್ ಮ್ಯಾರಿಡ್ ಈಸ್ child, a female should have completed 18 years and male should have completed 21 years. So if a male has not completed 21 years, under that act he is a child. You can't apply that definition here. ಅಲ್ಲಿ 21 ನಿಲ್ತರಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಿ ಅದು ಆ ಆ್ಯಕ್ಟಿಗೆ ಮಾತ್ರ ಅವ್ನು ಚೈಲ್ಡ್. ಅವ್ನು 21 ವರ್ಷ ಆಗಿದ್ರು ಸಹ ಅವ್ನು ಚೈಲ್ಡ್. ಸೊ ಅವ್ರು 20 ವರ್ಷಕ್ಕೆ ಮದುವೆ ಆದರೆ he can be booked under the relevant provisions of the Child Prohibition Marriage Act. ನೀವು ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ that act says that child marriage is voidable. ಇದು ಹೇಳ್ತಾ ಹೋದರೆ ಬಹಳ ಮುಂದೆ ಕೊಟ್ಟು ಹೋಗುತ್ತೆ. ವಾಯ್ಡಬಲ್ ಅಂದರೆ ಏನು? ವಾಯ್ಡಬಲ್ ಅಟ್ ದಿ ಬಿಹೆಸ್ಟ್ ಆಫ್ ದಿ ಬ್ರೈಡ್. ಏನು ಹಾಗಂದರೆ, ಯಾವ ಹೆಣ್ಮಗಳು ಆ ಥರ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿರ್ತಾಳೋ, ಯಾವ ಹೆಣ್ಮಗಳು ಆ ಥರ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾಳೋ, ಅವಳು ಬೇಕಾದರೆ ಆ ಮ್ಯಾರೇಜ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸ್ಕೋಬೋದು. ವಾಯ್ಡಬಲ್ ಅನ್ನೋ ಪದ ಸೆಂಟ್ರಲ್ ಆ್ಯಕ್ಟಲ್ಲಿ ಉಪಯೋಗಿಸಿದೆ. ಆದರೆ ನಮ್ಮ ಸ್ಟೇಟ್ ಆ್ಯಕ್ಟ್ ಅದಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ತಂದಿದೆ. ಅದು ಐ ಥಿಂಕ್ ಮಾರ್ಚ್ 2003 ಏನೋ ಜಾರಿಗೆ ಬಂದಿದೆ. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಇಟ್ ಈಸ್ ನಾಟ್ ವಾಯ್ಡಬಲ್, ಇಟ್ ಈಸ್ ವಾಯ್ಡ್. ಇಟ್ ಈಸ್ ವಾಯ್ಡ್ ಅಂದ್ರೇನು? ಶೂನ್ಯ. ದಟ್ ಮ್ಯಾರೇಜ್ ಈಸ್ ನಾಟ್ ಅಟ್ ಆಲ್ deemed to be not in existence. They are not at all husband and wife. ಇದನ್ನು ಇದೇ ಜಡ್ಜ್ಮೆಂಟಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ ಸ್ಟೇಟ್ ಮಾಡಿರೋ ಅಮೆಂಡ್ಮೆಂಟ್ನ ಅಪ್ರಿಷಿಯೇಟ್ ಕೇಳಿದ್ದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ದ ಮೋಸ್ಟ್ ಆಬ್ವಿಯಸ್ ಆ್ಯಂಡ್ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ರೆಸಲ್ಯೂಷನ್ ಆಫ್ ದಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪ್ರೊವೈಡೆಡ್ ಬೈ ದಿ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ಓದ್ತಿರೋದು. ದ ಸ್ಟೇಟ್ ಲೆಜಿಸ್ಲೇಚರ್ ಹ್ಯಾಸ್ ಇನ್ಸರ್ಟೆಡ್ ಸಬ್ಸೆಕ್ಷನ್ 1 capital A in section 3 of the prevention of prohibition of child marriage act declaring that henceforth, that is from that day onwards, every child marriage that is solemnized is void ab initio. Ab initio means from the beginning. It is void from the beginning. So that has been appreciated. ಅದನ್ನು ಹೇಳಬೇಕಲ್ವಾ? ಯಾಕೆಂದರೆ ನಮಗೆ ಅದೇ ಮುಖ್ಯ. Therefore the husband of a girl child would be liable for punishment for child marriage under the Prohibition of Child Marriage Act for penetrative sexual assault or aggravated penetrative sexual assault under the POCSO Act. And if the husband and the girl child are living together in the same or shared household for rape under IPC, aವಾಗ IPC ಇತ್ತು, ಇವಾಗ ಚೇಂಜ್ ಆಗ್ತಾ ಇದೆ. It would be wise for all the state legislatures to adopt the Karnataka formula. This is what the Supreme Court has said. So, this particular inclusion, or by substituting 18 years in place of 15 years, has got such a wide change in the field of, in protecting the rights of a female.
ಇದು ಏಷ್ಯಾನೆಟ್ ನ್ಯೂಸ್ ನೆಟ್ವರ್ಕ್ ಪ್ರಸ್ತುತಿ.
ನೀವು ನೋಡ್ತಿದ್ದೀರಾ ಏಷ್ಯಾನೆಟ್ ಸುವರ್ಣ ನ್ಯೂಸ್.